situation, they don't like the mom too well since she's already been through 3 due process filings with them. And so the kid was going into high school, and all of her peers were going down the road to Ayala, as a matter of fact. And they wanted her to go to Don Lugo. There wasn't any reason to make her go to Don Lugo. They just wanted to break the woman's chops. And they said, well, you're under idea, we don't have to give you that. Which was maybe true. At least it was going to be a point of dispute. So we filed for a 504 due process hearing saying that they were not accommodating her disability, which is fetal alcohol syndrome. And they were endangering her. And the next news you know, she was 102nd in the inter-district transfer list, but the next news you know, she got a notice the next week saying, you know, she can go to Ayala. So we withdrew the request. What was very complicated under IDEA was very simple under 504. Didn't need a lawyer or anything else. Another case we had like that, we had a Down syndrome kid, but he was a smart Down syndrome kid. They wanted to put him in a really crappy county program, a 25-minute drive away and about an hour ride in a bus, which is going to absolutely destroy his day. So we filed a 504 hearing request on that on the basis that they were retaliating against him on account of his, discriminating against him actually on account of his disability by just destroying his community supports, because he was going to be leaving an hour early in the morning, he was going to be coming home an hour late, he was going to, whatever. So by the time he got finished with all of that, he ended up in his home school with an A and things. He's doing very well. And in fact, they're very happy. And the district ended up saving money. Now, one common form of retaliation, which is sometimes inadvertent, sometimes it's just ignorant. But school people will tell you, well, he has an IP, so that means he doesn't get 504 stuff anymore. Yeah, he does. If they're telling you that you can't have your 504 protections on account of an IP, they're retaliating against you for exercising your IDEA rights. Okay, because you're using IDEA, you can't have your civil rights anymore? That's retaliation. So you always think of 504 first when you're looking at these things. Are they violating my kid's rights? Then you talk about IDEA, what is he entitled to under special education? But never let it get far from your head. This is a civil rights issue. Are they in fact depriving my kid of his civil rights? And if they are, they can't talk about IDEA and educational things and stuff that's appropriate somehow or other. Look, the black kid's allowed to ride in the front of the bus like everybody else. And if somebody or other thinks that's not educationally appropriate, tough. Gets to ride in the front if he wants anyway. So that's the thing about 504 that helps to protect you from being bullied by supposed educational experts into things. Because if the kid has rights, it doesn't matter how dumb they think it is for you to exercise your rights. You exercise them anyway. So that's a reason to keep it simple in that way. Because otherwise, people, if they have smarts and different things, and they know the educational jargon, it's very easy for them to lead you around by the nose, and the next news you know, you've lost everything that you needed for your kid, and they've all explained how it makes sense. So the simpler you can keep it, the less likely that is to happen. So I've been sort of going there anyway, but I'd like to go through some comparisons with 504 and IDEA. In a way, when you look at the surface, they kind of look the same, and 504 sort of looks like a junior version of IDEA, right? They both provide services. One provides services through an IP. The other one they can do through a 504 plan. And IDEA has some detailed procedural safeguards, a great big statute and all kinds of regulations. And 504 has some procedural safeguards too, a lot simpler, but they're there. And IDEA provides for due process hearings with the state. And 504 provides for a due process hearing that the district has to provide. So they look the same, but a lot of different things. But as I was saying here, embarazada does not mean embarrassed. And I can say, I am an advocate, but I better not say, yo soy abogado, because I'm not a lawyer. So they look the same on the surface, but they're actually quite different. For example, under IDEA, which is not really a civil rights statute, it has certain civil rights aspects to it, especially the procedural safeguards. Really, it's not. Under IDEA, the IP defines what the services are that the kid needs. And if the IP was arrived at correctly, and you can defend the assessments and everything, that's what it is. And so it all really depends on the IP. And the only way you can challenge things in the IP is show there's something wrong with it. They didn't allow parent participation, or they didn't assess properly, or a lot of things like that. You can fight the IP, but basically the IP is the bottom line once it's been agreed on what it is. The 504 plan doesn't even have to exist. The 504 plan doesn't necessarily have to involve any parent participation if it does exist. Because the 504 plan doesn't determine what the services are. The 504 plan says this is what the district thinks we need to do in order to obey Section 504. But whether they did or not doesn't depend on the plan, it depends on the law. The law just sits there. The kid needs these different things, and the 504 plan may say them and may not, but whatever. Now, are there any questions that should I stop? Because we're going to have questions later anyway. But we can have them now. Now, under IDEA, the student gets qualified under one of 13 different conditions defined by 34 CFR 300.8, which is the federal regulation that lists all these things. There's autism, there's mental retardation, which they now call intellectual disability, which is all that's going to do any good. And a variety of other health impairment. Don't remember them all. I'd have to look them up. Under 504, and that qualification process under IDEA involves assessment, and you argue about whether the kid qualifies or not. Under 504, the kid qualifies, the person qualifies if he has a disability that interferes with a major life activity. It could be learning, sleeping, working, and it's not an exhaustive list. And not only that, even if the kid doesn't actually have the disability, if he's considered to have the disability, or if he's treated like he has the disability, he still qualifies. Basically, it's written like this to keep people from arguing about whether the kid qualifies. So, another big difference is that IDEA, not really being a civil rights law, it doesn't really have protection against retaliation. It does indirectly. If they retaliate against you, you can argue that they prevented parent participation by intimidating you, or lying to you, or hurting you for exercising your rights, and because of that, their offer is not actually a valid offer of faith. But there's no actual claim for retaliation. It's just that if you can prove retaliation, then you can prove that their offer isn't any good because it wasn't arrived at properly, which is better than nothing. But it's not a straightforward civil rights thing. Under 504, you have very strong anti-retaliation protections. There's money damages possible. There's various and sundry other punishments possible. And there is a procedure that the Office for Civil Rights will go through. And it's very easy for them to get into trouble for it. So if you file a complaint, and then they turn around and they don't let you talk to anybody but the superintendent, or they insist that they say, well, you can't observe in the kid's class anymore because you're litigating, any of that kind of stuff is retaliation. if they single your kid out for mistreatment because they don't like the way you're acting. That's retaliation. So there's very good protection under 504, which under IDEA you guys sort of end up in the mush and you don't get anything very clear. So that concludes that stuff. I want to mention, here's the different links and contact information. And then there is also some stuff on the back here. I quoted different regulations that were specific, and I the FAPE requirement, for example, under 504, which says appropriate education. For the purpose of this subpart, the provision of an appropriate education is the provision of regular or special education and related aids and services that are designed to meet individual educational needs of handicapped persons as adequately as the needs of non-handicapped persons are met, and are based on adherence to procedures that satisfy the requirements of 104.34, 104.35, which is assessment, and 104.36. So it's a pretty broad-ranging thing. You will hear from people, usually because they don't know better, but sometimes they do, that, 104 doesn't give you anything. It just means that they'll accommodate your diabetes and stuff like that. They owe you a free, appropriate public education, just like they do under IDEA. So with that, I want to open it up to questions, especially since questions are very important. Questions, comments, arguments, disputes, all of that is fine.
He has a question. I heard that why is it that at meetings or IP meetings or any type of meetings, what we really need to know our rights, why is it in small letters?
Oh, I'll tell you why, pal, because they don't really want you to know. Sometimes they're pretty audacious. In the last meeting, and I don't know whether the woman was dumb or whether she really thought this, but she's going through the procedural safeguards, explaining things, right? And she comes to the independent educational evaluation part, and she says, you can have an independent educational evaluation, which the district pays for, but only if the district agrees. Well, so we had a conversation about that. No, and I said, no, it's not only if the district agrees. If the district disagrees, they got to take you to due process and prove that their evaluation is okay. They just can't say, well, we disagree. If they disagree, they got to file with the hearing office. I want a due process hearing, and they got to prove it, and they can't take all day. If they go a couple of months and fart around, then it's too late. The Pajaro case, the district, the Pajaro district, this was, I think, back in 2003. The Pajaro district up in Northern California, they didn't agree to give the IE, but they didn't file either. They just sort of sat there, figured the time would go by. So the Ninth Circuit said, you let 3 months go by, you just got to give it to them. So that kind of thing happens all the time. You do not expect them to tell you your rights for you. It's the same way, if you want to go to court, you don't go to the prosecutor and ask him how you're supposed to defend yourself. You go to the SELPA, you can ask different things from the SELPA, but you don't listen, you don't believe what the SELPA tells you. You listen to what the SELPA tells you, that's okay, but the SELPA is not there to take care of you. The SELPA is there to take care of the district. And it may be a good district, and it may be a bad district, but I don't care what district it is, it's a district that wants to take care of the district. Just like you're a parent who wants to take care of the kid. You're never really going to want to take care of the district, and they're never really going to want to take care of the kid. Everybody wants to take care of themselves. Nothing to be mad about, that's just how it is. So that's why we need to study. We need to learn our different rights. As I was saying before, a basic point of negotiation is that you want to let people feel good in exchange for giving away what they ought to have. So if you want to go away with everybody feeling good and liking you, the only way that's going to happen is you give away stuff that your kid ought to have. Now the thing is, you be nice to people, you be polite, you treat them correctly, you bring grapes to the IP meeting, or oranges or something like that. You do all that kind of stuff. But the bottom line is, when it's a choice between taking care of your kids and making them like you, make them hate you. And it's all good, clean fun. They understand this. It's their job to make you feel bad about asking for things that you need. And it's your job to realize that's what their job is. But the thing is, you're going to have to live with your kid for 20 years. They're not going to have to live with your kid for 20 years. You need to look out for your kid. They're not happy about it. Tough on your budget. Makes their life complicated. Okay, cry a couple tears, but make sure you get what your kid needs. And know that they're not necessarily going to like it. It's okay. You work on a car, you're going to get grit under your fingernails. You work in daycare, you're going to have to change diapers. You advocate for your kid, they're not going to like you. It's okay. So, any more questions, comments, arguments? There should be some.
These all questions, comments, arguments?
Do you have this forms in Spanish?
Elena was supposed to translate it. I gave it to her too late. I was a bad boy. My day job went interrupted. And then I had to write a couple of motions for a hearing that's coming up.
Is she still in here, Peter?
Elena's around. And she knows that she's got to make these in Spanish.
You know what? There is a function in the system